Good morning. I'm Mary Catherine Waldron, Managing Senior Advisor for the Health and Welfare Compliance Department. I'm standing in as host for today's presentation, and thank you so much for joining us for part one of our two-part answer session on the American Rescue Plan Act and the outbreak period. All questions addressed today were submitted over the last few weeks, and we are working diligently to provide the best answers possible. Today, we're discussing general questions, subsidy-related questions, and questions pertaining to voluntary versus involuntary termination. Next Tuesday, we'll discuss dependent care and notices. Today's presentation is being recorded, and we will provide the slide deck and recording to you as soon as it is available. There were also a handful of questions received that needed further investigation, so we'll do our best to provide answers to those next week. Any questions we receive in the panel today will also be addressed next Tuesday. Thank you so much for joining us, and as always, thank you for your trust, patience, and patronage. Michelle Barki is here with me today, Director of our Health and Welfare Compliance Department, and we'll go ahead and get started with our long list of questions. Are you ready, Michelle?
I'm ready, Mary Catherine, and let's do it.
Okay. So, question one. Will Cobra members be able to have a gap in coverage?
Yes, for those that involuntarily terminated and are entitled to the subsidy, there is a special enrollment right from April the 1st through September the 30th, and it is not contingent on having Cobra coverage prior to April the 1st, 2021. So there can be that gap in coverage.
What if a group plan was replaced with an employer-subsidized ICHRA? Does every assistance-eligible individual have the right to a 100% subsidized ICHRA? Will an ALE employer have to make the affordability contribution for everyone who elects the subsidized ICHRA plan?
Yes, ICHRA plans, the individual coverage HRAs are also entitled to the subsidy. So yes, they have to do that. Now, if you're a small qualified employer HRA, which for those employees that are employers that are under 50, those small qualified employer HRAs are not subject to the subsidy.
So if an employee canceled their Cobra coverage before the 18 months ended, will these changes allow them to enroll again? And if the employee termed February 2020 with a Cobra effective 3/1/2020 date?
Yes, as long as they're within that 18 months of Cobra eligibility, there is a special enrollment right just for April the 1st through September the 30th, even though there is that gap of coverage and they elected and then terminated, they would still be entitled to the subsidy if they were involuntarily terminated.
And have the carriers agreed to accept the retro enrollments?
They really don't have a choice. If you have any issues with the carriers, we would love to hear about it. The National Association for Healthcare Underwriters has not indicated that there's any changes with the carrier, but we know with carriers, you just never know what they're going to try to do. But this is the law and they must comply. And as we know from the outbreak period, they seem to be much more accepted to retro enrollments than they are to retro terminations. But this is actually a special enrollment, right?
Okay. So just to clarify, the recently signed bill allows reinstatement just as of 4/1/2021 going forward, up to the end of their normal Cobra period allowed within 6 months of the subsidy?
This is correct. It will not extend the Cobra beyond the 18 months, but from April the 1st, 2021 through September the 30th of 2021, if they are an AIE, an employee assisted eligible individual, which means they were involuntarily terminated or they had a reduction at hours, they can get the subsidy. What is not clear is whether they can continue Cobra after September 30th, and we're still looking at that if they do not retro pay all their premiums. And don't forget, we also have the outbreak period, which is still going on. So individuals, regardless as to whether or not they're entitled to the subsidy, can still possibly elect Cobra.
Will this apply to states that offer continuation for groups smaller than federal Cobra employees, which is typically 20 or more?
Absolutely. State continuation applies.
And is the coverage period backdated to original Cobra beneficiary effective date, or is the coverage period just April 1st through September 30th, 2021?
For those assistant eligible individuals, there is that special enrollment period just from April the 1st to September the 30th, where they're entitled to a subsidy if they involuntarily terminated or if they had a reduction of hours. And you do not have to be enrolled in Cobra at that time in order to take advantage of the subsidy, as long as you're within your 18-month Cobra period.
Does an employee who elected Cobra last year and is still in their 18 months receive the subsidy, or is it only for those who elect during the special enrollment period?
If they are still in their 18 months and qualify as an employee eligible individual, i.e. they were involuntarily terminated or they had a reduction in hours, they would qualify for the subsidy if the qualifying event was, again, involuntarily termination or if it was for a reduction of hours.
Okay. So, what if the Cobra qualifying event is the end of FMLA?
That's a very interesting question. If they do not return at the end of FMLA because they're sick and unable to work, this would probably be considered an involuntary termination. Although we don't really have any guidance under the American Rescue Plan Act, we did under ARA, that was in 2009, and we can draw some analogies. We believe that it will be the same. Under ARA, the IRS stated involuntary termination of employment was a severance from employment due to the independent exercise of the unilateral authority of the employer to terminate employment, other than due to the employee's implicit or explicit request, where the employee was willing and able to continue to provide services. So if the employee is not able to provide services and the employer has to terminate them, we believe this is an involuntary termination and that they will be entitled to the subsidy. So again, we have to look back, is the employee willing and able to provide the services? And if not, and the employer terminates them, then that would probably be covered under the subsidy.
Okay. What if an employee who was unable to return from FMLA in October and was terminated and has Cobra currently, do we now roll them into the subsidy program effective April 1?
Yes, if the termination was involuntary or if they had a reduction of hours, if they are currently enrolled in Cobra and were not offered any other group health coverage or Medicare, then they should be enrolled in the subsidy program. And the model notices should clarify this. However, we're still awaiting the model notices.
Okay. So what if the employer discontinued their medical plan due to major layoff? For example, for groups under 20 in California, there is a California Cobra with a 10% surcharge. How will that work?
Again, if they laid them off and they canceled the medical plan due to the major layoff, they probably will not be entitled to this Cobra subsidy because there is no plan to put them in. If they had continued their medical plan, then they would have to give them the subsidy. But without a medical plan, there's no Cobra.
And how do these regulations apply for non-ERISA groups?
Cobra subsidies apply to all group plans, including state continuation. The outbreak period is mandatory for ERISA plans and voluntary for government plans, although the subsidies are required for all plans, all group health plans.
Which admin would be responsible to this if the employer has changed vendors during this time?
This is a great question, and it has become one of the leading questions that we have. The question is complicated by the fact that the plan sponsor is the fiduciary, and the plan sponsor is the employer of the health plan. So they are the ones that are going to have to determine whether or not, who is qualified and get the notices out. Now, the administrators, we have heard word that administrators who have been terminated are not getting the notices out. And the new administrators are saying, we don't have the information, so we're not going to do that. The only thing I can tell you from Medcom's point of view is Medcom, we have made the decision ourselves that if we take over a new group and the new group can get us all the information on those terminated employees, and we have a template for them to do so, that were involuntarily terminated, then we will handle it. But again, this is something that is completely new, and the administrators are going to have to come up with a way to handle it. But you're right, some new, who changed plans during this period could find themselves between a rock and a hard place.
If a Cobra participant has already paid their premiums for April, how will they get the refund for the Cobra payment?
The employer is going to have to reimburse them, and they have 60 days to do so.
Okay. So if an employee is currently on Cobra but has not made payment and the group moves carriers, does the employer need to allow employees to enroll with the new carrier even if they haven't made payment for several months?
If they are in the outbreak period, yes. And if it's for the subsidies and they qualify between April and September the 30th, yes, they will have to allow them to do so. I'm a little bit curious when they said they're currently on Cobra, but they haven't made any premiums, as to whether the employer has been making the premiums all along. So that would be something that we would have to discuss separately. And we'll get the person who wrote that question and get back to them. But typically, they're in the outbreak period, they're still entitled to pay their back premiums and get onto Cobra. And if they're a subsidy eligible individual, i.e. an AIE, that was involuntarily terminated or had a reduction in hours, they should be able to get the Cobra for April the 1st through September the 30th.
Okay. If an employee who was terminated elected Cobra and has been paying premiums, will they now be instructed that they don't have to pay?
If they were involuntarily terminated or had a reduction of hours, and that was the reason for the qualifying event, then yes, they will get a notice of availability of the substance. And any premiums that they've already paid from April the 1st through September the 30th would have to be reimbursed within 60 days.
If the Cobra qualified beneficiary has a new special enrollment right under Cobra for 4/1 through 9/30, are they able to randomly elect any start date within that timeline to start their 18 months, or is it reduced?
Okay, this is not a restart of the 18 months. The 18 months starts when the qualifying event occurred. But in fact, they can elect Cobra during this time and get the subsidy. If they have other coverage elsewhere, other group coverage elsewhere, then they're not entitled to that subsidy. It has to be group coverage or Medicare. But I don't see anybody picking and starting and choosing which date it's going to be. Most would probably want it from April when they first qualify. But again, I want to emphasize this is not a restart of the 18 months.
Okay. What happens if a former employee elects Cobra and we pay it, but it turns out they have other coverage? Do we get a refund?
You should really go after the employee in this case. But again, I would look to see what your plan document said about other coverage and Cobra. In addition, part of the subsidy availability notice will also be a statement that the employee has the obligation to let the employer know if they have even an offer of other group coverage. And again, for the subsidy, it's group coverage or Medicare. And it doesn't mean they even have to have taken it, but if they have an offer of other group coverage, they're not entitled to the subsidy. And if they fail to advise the employer, the penalty is going to be $250. But if it is determined that they intentionally, i.e. knew that they had to notify and did not, the penalty is going to be the greater of 250 or 110% of the subsidy.
Does the participant have to pay retroactive premiums to enroll under the new special open enrollment period? How about
They do,
adverse selection?
the adverse selection is a really good question. They do not have to enroll retroactively. And, adverse selection is a concern, but think of it this way as well. If they didn't take the retroactive coverage, this could also mean that they are healthy and did not incur large claims. Only time will tell about the adverse selection on this one.
Who qualifies for this subsidy? Is it all involuntary terms or only those that were involuntarily termed due to COVID?
It's all involuntary terminations except for gross misconduct, provided they are within their 18 months of any part of the subsidy months. And it's also for those that had a reduction of hours. It doesn't have to be specifically related to COVID.
And are subsidies optional or are they required?
They are required for all assistant eligible individuals.
Is it the carrier or the employer that pays the subsidy and takes the payroll credit for a fully insured plan?
This is a question that has been coming up over and over and over, and it was due to confusion in the original bill. The original bill said that it was the carrier for fully insured and the employer for self-funded, but with the final bill, it was changed so that it's employers for both the fully insured and self-funded. And it only makes sense because only the employers can take that payroll tax credit that they will get.
Okay. And so is that subsidy required for state continuation?
Yes.
Okay. If a terminated employee gets a new job, do we have to continue to provide the Cobra subsidy?
You pay unless they have an offer of coverage under another group plan. So until they get that offer of coverage, they will be entitled to that subsidy. Figure that there might be a waiting period under that new group plan. So it's not the question of getting a job, it's when that offer of coverage comes through. And again, as we mentioned, as part of the notice requirement, Cobra participants will be advised as to the penalties for failure to advise once they have that offer of group coverage.
So does this Cobra subsidy include furloughed workers?
Yes, if they lost their coverage and are entitled to Cobra because it is an involuntary termination.
Okay. If a former employee lost Cobra for non-payment of premium last December, are they now able to pay the premium back to December and have claims covered during that time frame? Can they skip January through March and re-enroll in April with a subsidy?
Okay. Probably due to the new outbreak rules. Don't forget the outbreak rules are separate from the Cobra subsidy rules. And now employees are allowed to go back to 1 year from the date that they actually would have been entitled to benefits and then elect those benefits, or 60 days past the end of the national emergency, whichever comes first. So they still are in the outbreak period. So yes, if it was last December of 2020, they would be able to make those premiums up until, if that was their last day of work, they would be able to make the premiums. So it's going to go back to when they were actually terminated and when their year time frame is up under the outbreak period. They can then skip January through March. And yes, if the April is within the 18th month, 18 months of their original Cobra eligibility, then yes, they can then re-enroll under the special enrollment right. And again, this is all contingent upon what caused them to lose coverage to begin with, if it was an involuntary termination or if it was a reduction of hours. If they terminated on their own volition, they quit their job, got another job, they would not be entitled to the subsidy, but they would be entitled under the outbreak period.
So, if someone was terminated for just cause, do they still qualify for the subsidy?
Yes, it must reach the standard of gross negligence not to be eligible. And gross negligence has not been defined within the Cobra laws, but it is pretty significant. It has nothing to do with whether or not they had performance issues, whether they were tardy, or anything regarding that. Gross negligence is a higher standard. For an example, one of the cases on gross negligence was a salesman. He had a company car. In the policies and the procedures, they said you're not allowed to drink and drive at all. So you're not allowed to have drinks at lunchtime. He went out, had drinks at lunchtime, got into a very severe car accident. Company was sued, and he got DUI, of course. That was considered gross negligence, gross misconduct, and he was actually not offered Cobra. Sad point of that case, his wife was 9 months pregnant and the coverage for the pregnancy was not covered. But before you ever go to gross misconduct, please contact your attorney because they have to reach a very, very high standard.
Would dropping Cobra at the end of the subsidy qualify as a special enrollment for someone to then enroll on the marketplace?
You know, normally voluntarily dropping Cobra is not a special enrollment, right? Or they don't have a special enrollment periods. Indications are that they might allow that, but we do not know at this time. I will tell you, a couple of days ago, we know that President Biden had an open enrollment between February 1st and May 5th and May. Now that has been increased to August the 15th. So we're coming to the end of the subsidy period. We don't know what he's going to do going forward.
Does the subsidy apply to just medical or to all Cobra coverages like dental and vision?
It also applies to dental and vision. It
Okay.
does not apply to FSAs.
Does the 100% premium subsidy also apply to disabled participants who are paying 150% of cost?
It does not, and I'll tell you why. It does not go beyond the 18 months of Cobra eligibility for that first 18 months. And those disabled are between the 19th month and the 29th month. So they would have already satisfied the first 18 months. So no, they would not be covered.
Okay. So does the subsidy cover just the employee premium or the dependent portion as well?
The dependents and spouses, if they are qualified beneficiaries and were on the plan prior to the involuntary termination or reduction in hours, would also be covered.
Okay. And what happens if the carrier does not allow the SEP for the Cobra coverage during the subsidy timeframe?
And again, this is part of the American Rescue Plan Act. I don't think they have a choice. We have not heard any indication that they are not going to do it. I would be very, very aggressive with making sure that they are covering it during that period of time. I don't really think they have a choice.
Okay. If a group's open enrollment falls between April and September, would a Cobra qualified participant be able to increase their plan election and still get a full premium subsidy?
You know, at this stage of the game, the government has not made any indication of what would happen between April and September if that was the group's open enrollment period. What they have said is during the subsidy period that they can lower the cost of a plan. It's going to be a very interesting conversation when it comes up. But at this stage of the game, there's no indication that they would be allowed to increase. However, we know under open enrollment, they can choose whatever plan they want. We don't really know how this is going to work out.
Here's an interesting question. Do large group church plans need to provide subsidies?
Well, that is a very interesting question. You know, group church plans in general do not have to provide Cobra. So the answer to this is going to be one of twofold. If the large group plan is part of state continuation, and that is why they're offering the subsidies, then yes, they would have to offer the subsidies. If the large group plan has traditionally offered Cobra, then I would have to imagine they chose to be under ERISA and they would have to offer the benefits. But if a church plan is not following ERISA and has no state continuation to worry about, then they shouldn't have been offering Cobra to start, let alone the
That,
subsidy.
that makes a lot of sense. Okay. Does the subsidy apply to someone who has coverage elsewhere? For example, someone who was involuntarily terminated due to COVID layoffs, or since they got another job, or has since gotten another job, or has an offer of coverage?
Once they have other group coverage offer, regardless of whether they took the coverage, they are not entitled to the subsidy, and that is going to be part of the model notice.
Okay. So, are the qualifying events of involuntary termination and reduction in hours exclusively due to COVID RIF layoffs, furloughs, and other reorganizations due to economic impact of COVID?
No, if they were involuntarily terminated or had a reduction of hours for any reason, they are entitled to the Cobra subsidy. I think it would be a nightmare to administer otherwise, and the government said it was just involuntary termination.
So how will the new election period rule under the Act dovetail with the pause on Cobra deadlines announced on February 26th, the individual qualifying event rule for the 12-month maximum period?
Okay. Very, very good question. And this is one of the times I tell my clients to compartmentalize. You must keep them separate. There's two separate issues going on. The outbreak period allows all those covered under ERISA, and depending on the public entity, because it's voluntary, to pause their election period for 1 year unless the national emergency ends, and the outbreak period would then subsequently end 60 days later after the end of the national emergency. So we look at the earlier date. Now the ARPA is for employees who are involuntarily terminated or had a reduction of hours. And if they have a special enrollment right under Cobra subsidies, if they would have been Cobra eligible anywhere between the period of April the 1st and September the 30th, they do not have to have a Cobra coverage period prior to April the 1st, and those that have gaps in coverage still eligible. So we're looking at two separate things. We're looking at the outbreak period, 1 year from the date of eligibility. Their election and their premiums are paused until they determine what they want to do. It's for all employees under ERISA. And if the public entity chose to allow this, they would also be covered. The ARPA for the subsidies, April the 1st to December 30th, is a special enrollment right for those in anywhere in the 18 months, but only for those that were involuntarily terminated or that had a reduction of hours. So yes, somebody could very well be in the position of having both the outbreak and the subsidy, but only choose to go with the subsidy.
Okay, if a reduction in hours was voluntary and the now part-time individual is still employed but not benefits eligible, how does the ARPA allow for a subsidy?
You know, in reading the law a little bit further, yes, last time I said that I didn't think part-time, that those had a reduction of hours would be voluntarily had a reduction of hours. But there are a couple of indications in the law, very, very subtle, that it doesn't matter what reason for a reduction of hours, they would still be entitled to the subsidy.
Would you need us to provide termination information for employees who were involuntarily terminated? And if so, by when?
Yes, that's the multi-million-dollar question, and the answer is yes. And I think this is hitting all of the TPAs, because most of the platforms would give that indication, but there was no reason under Cobra to say anything except they terminated employment. That was the qualifying event. So yes, we do need to know who was involuntarily terminated and who had the reduction of hours. And Medcom Benefit Solutions is preparing notices to go out regarding this and what we are going to require and the deadlines we would like to have it back for. We have been currently working with the brokers on this, and just understand that the notices must be out for the subsidies no later than May 31st, according to the Department of Labor and to the American Recovery Rescue Plan.
Does the voluntary layoff have to be due to the pandemic or can it be for just cause?
It can be for just cause.
Okay. And here's our last question of the morning. Are employees who were terminated for not following procedures or fulfilling employment obligations eligible? For example, they were being fired for excessive tardiness.
No, it has to be gross misconduct. Always check with your attorney, your lawyers first, as we talked about before. Tardiness doesn't count. Failing to do your job doesn't count. Has to be more than that. It has to be gross misconduct. Stealing, for an example, as we talked about the guy that had the DUI, those kind of events. Always talk to your lawyer first.
Okay, well, Michelle, thank you so much for providing your expert knowledge on this complicated subject matter, and that I'm sure has a lot of head spinning. And I think you've calmed a lot of nerves today and provided a lot of information that's very helpful. That's it. Thank you so much for joining us today, Michelle. Thank you so much for providing all of those very helpful and insightful responses.
And thank you, Mary Catherine, for pinch hitting for Casey today.
Oh, of course, it was fun. All right, everyone, have a great day.